A constitutional framework that stood for 114 years just collapsed in a single afternoon. The Supreme Court's 6-3 ruling didn't just strike down one state's gun law, it destroyed the permit system that 9 states used to deny firearms to roughly 70% of ordinary Americans, all while fast-tracking approvals for celebrities, retired cops, and politically connected individuals. Before you click away, hit that subscribe button, because what I'm about to show you will change how you understand your Second Amendment rights. The case that brought down America's oldest gun control system wasn't filed by a massive lobbying group. 2 ordinary New Yorkers, Robert Nash and Brandon Koch, applied for concealed carry permits and were flatly rejected because they couldn't prove they faced special danger beyond what any other citizen experiences. Nash had completed firearms safety training, passed every background check, and had a completely clean record. Yet the licensing officer denied him because simply wanting to protect yourself wasn't enough. These rejections weren't unusual. They were standard in New York since 1911, determining whose constitutional rights deserved protection and whose didn't. The New York State Rifle and Pistol Association took the case to the Supreme Court, and in June 2022, Justice Clarence Thomas wrote the majority opinion that obliterated this 111-year-old system. But here's the part. Legal experts are still studying. The court didn't just strike down New York's law, it created a new legal standard that invalidates thousands of gun regulations across America without separate lawsuits for each one. The history and tradition test now forces prosecutors to prove that any gun restriction has a clear historical analog from the 1790s founding era. Modern crime stats, public safety arguments, or polling data are completely irrelevant. Federal judges in California spent months searching historical archives, trying to find evidence that colonists ever limited magazine capacity, and came up empty because ammunition-feeding devices didn't exist back then. A federal court in Illinois struck down the state's assault weapon ban after prosecutors couldn't produce a single example of founding-era Americans banning rifles based on features like adjustable stocks or pistol grips. The burden of proof is so high that the Congressional Research Service estimates over 300 state and federal gun laws are now constitutionally vulnerable. While legal scholars debate the implications, something dramatic is happening on the ground. The permit explosion nobody expected. Hawaii had issued 187 active concealed carry permits for a population of 1.4 million, an approval rate of roughly 0.1%. Within 8 months of the Bruin decision, Hawaii processed over 3,800 new applications, with approval rates in Honolulu County jumping to 82% for applicants who met basic training and background check requirements. California's numbers are even more shocking. Los Angeles County, which had roughly 400 permits for 10 million residents, suddenly faced a backlog of over 8,000 applications within the first 6 months after Bruin. New Jersey, previously approving only 1,200 permits statewide annually, saw applications surge past 45,000 in the first year post-Bruin. The financial impact on states has been massive. New York, which previously handled roughly 5,000 applications per year, suddenly faced 60,000 plus new applications, forcing the state to hire 87 additional licensing staff at a cost of over $4.2 million annually. California responded with SB 5B2, designating nearly every public location as a sensitive place where concealed carry is prohibited, effectively rendering permits useless in 90% of urban areas. This includes government buildings, public transportation, parks, playgrounds, entertainment venues, libraries, medical facilities, banks, and even private property, unless the owner posts explicit permission, which almost no business does. San Francisco mapping shows that a permit holder cannot legally carry continuously for more than 3 city blocks before entering a prohibited area, making lawful carry functionally impossible. New York responded aggressively as well, passing emergency legislation creating 23 categories of sensitive places and requiring applicants to submit 3 years of social media information, giving licensing officers broad discretion to deny permits based on speech or opinions Americans they find objectionable. Even the firearms, training, and permit processing industry faces existential threats. This billion-dollar ecosystem earns roughly $1.3 billion annually from courses, application fees, fingerprinting, and renewals. California's 16-hour training costs $200–400, generating $25–40 million in fees in the first year post-Bruin. Maryland's similar system generates around $18 million annually. Federal courts are now questioning whether states can constitutionally mandate expensive training requirements that didn't exist during the founding era, effectively pricing out low-income Americans from exercising Second Amendment rights. Across the country, 312 lawsuits are challenging gun laws under the Bruin framework. These cases will determine whether Americans face strict regulations or constitutional carry nationwide in the next 5 years. Some examples: laws banning 18 to 20-year-olds from purchasing handguns, lifetime firearm bans for non-violent felons, California's 10-day waiting period for law-abiding gun owners, Illinois' assault weapon ban, which could reach the Supreme Court by 2026. Since Bruin, gun rights organizations have filed over $87 million in legal challenges, systematically targeting every restriction that cannot meet the historical analogs test. The Supreme Court has already agreed to hear one major Second Amendment case this term, which could cement the most significant expansion of gun rights in a century, or preserve what remains of America's gun control framework. Meanwhile, anti-gun politicians are using every bureaucratic tool to strangle the ruling through malicious compliance and legislative warfare. If you want to stay ahead of new restrictions in your state, smash that subscribe button and turn on notifications. You won't want to miss a single update.